bill, and the outline of a bill that Assemblymember Gallagher and Senator Hoylman are currently carrying, numbered 9415 in the Assembly and 8439 in the Senate, alternatively known as the LLC Transparency Act. Thank you to Open Ownership, one of the groups we will be hearing from today, for this graphic, which I've plundered from their website. And without further ado, I want to talk a little bit about the ground rules for the meeting. Please keep yourself muted unless you're speaking. Please don't interrupt the speakers. We're going to be hearing from about 7 different groups who have all prepared very smart things to say. And we will have a Q&A section at the end. And so if you have questions, please hold on to them until then, or drop them in the chat. If you have comments, feel free to, like I said, mention them in the chat, but please don't blow up the chat. It might be distracting for some of the speakers. And at the end, when we get to the Q&A, feel free to raise your hand and we will call on you and take questions in order. Thank you so much. The order of things will be that we'll hear some brief remarks from the sponsors of the legislation. I will do a quick summary of the bill, and then we'll hear from our speakers. And then that is that. Hopefully we'll be wrapping up right at 11. Okay, so I think we will have Senator Hoylman say a few things if he is ready. And if not, then I can go directly to summarizing the bill. How about I do that? Do you want to move the slides towards
considering how long it took us to get in the building.
Sorry, we're having a bit of technical difficulties. Both the senator and the assembly member are in committee meetings that also start at 10 o'clock. And so they will, I think, hop on as soon as they're ready. So here's the run of show. And we're going to skip the slides, and I'm going to talk briefly about what this bill does. So first of all, I have to mention that the bill was amended right before this briefing. A9415 will be is on the Corporations Committee agenda for 11 o'clock today, where hopefully it will pass and go to the floor. The bill had to be broken into different pieces at the last minute because apparently in its intact nature, it would have required a referral to a second committee, and there's not time left in the session to move through multiple committees. And so I'm going to be talking about the different pieces of the original LLC Transparency Act, and specifically what each one does and why we need to pass all 3. The first part is the piece of the legislation that will be moving through committee today, which defines a beneficial owner in the LLC law. It requires the identification of beneficial owners to the Department of State upon LLC registration or formation. And it requires disclosure of changes to beneficial ownership to Department of State. It captures both New York LLCs and LLCs that are organized elsewhere. The difference between registration and formation is that an LLC can be organized in New York. It can be formed in New York. That makes it a domestic LLC, but also LLCs that are organized elsewhere, and many are, such as Delaware, still have to register with the Department of State in order to do business in New York. So requiring the disclosure of beneficial owners upon registration or formation captures both out-of-state and in-state LLCs. And if you are worried about any decline in revenue or something like that, the fee to register an out-of-state LLC to do business in New York is actually higher than the fee to form an LLC in New York. And so if any LLCs thought that they were evading this law by forming in Delaware, not only will they not evade the law, it will actually result in a net increase in revenue for Department of State. Next slide. So I use the word beneficial owner a lot. You're probably going to be hearing about it during the briefing. The beneficial owner is a true owner of a legal or business entity or asset as distinct from the legal owner. Currently, in the LLC world, the legal owner can be a registered agent, a trust, or a corporate intermediary acting on behalf of the beneficial owner. In practice, that means that LLCs can be basically anonymous, because if you do not record who the beneficial owner is, it is impossible to know who is actually profiting from or controlling an LLC. You can have an LLC landlord whose registered agent is the property manager, but that doesn't really tell you who actually owns the building or is collecting or profiting from rent. Beneficial owners can exercise direct or indirect control, which is very important. Could you go to the next slide? I have a couple of graphs here that sort of explain what that means. I've plundered these from Google Images. All credit to those who created them, including the one on the left, which was created by Open Ownership, one of the groups we'll be speaking today. But you can see here the difference between a beneficial owner and that is indirect and a direct beneficial owner. On the left, the legal owner who owns 50% of company D, person A, is a beneficial owner that is exercising direct beneficial ownership control. But person B is exercising indirect beneficial ownership control through a corporate intermediary, company C. And you'll see the same thing in the graphic on the right. Mr. Y and Mr. X are both beneficial owners, but Mr. X is indirect because he is a beneficial owner through company B and company C. The other thing that the graphic on the right displays is that beneficial ownership can have different percentages of control through equity or control of a board. Mr. Y has a 70% stake in company A. Mr. X, even though he is an indirect beneficial owner, only has a 26% stake. Mr. Z is an indirect beneficial owner, but only has a 4% beneficial ownership stake. It's not as important. And the law as proposed will only record indirect beneficial ownership over 25%, which is something we'll get to later. Could you go to the next slide? I'm going to skip this because it's sort of complicated, but this sort of shows these two next slides sort of show how in the real world, how complicated indirect beneficial ownership can get. Could you go to the next slide? Really quickly, this is a graphic that Open Ownership created that actually shows the real world networks of beneficial ownership of the company that owned the cargo on the cargo ship that blew up in the port of Beirut a couple of years ago, causing extensive damage to the city and to the port. If it were not for public beneficial ownership registries that have already been implemented or committed to in over 100 countries around the world, this information would not be obtainable. And we would not actually be able to figure out who is responsible for the cargo that exploded in the port of Beirut. And as you can see, these networks of ownership can become incredibly complex. And that is the world that we live in. And that is why we need beneficial ownership transparency legislation and public registries of beneficial ownership transparency. And in order to elucidate that and illuminate those reasons further, we're going to be hearing from a few speakers. I want to check first, Senator Hoylman, do you want to, actually, I forgot, there are other components to the legislation, sorry about that. So really quickly, part 2 of the public registry. This was in the intact version of the bill, but will be introduced as a separate standalone bill. If you were a supporter of A9415 before it was amended, we're going to ask that you also keep an eye out for this bill and co-sponsor it as well. This would collect all of the beneficial ownership information disclosed to Department of State and publish the names and addresses of beneficial ownerships in a publicly searchable registry. There would be a privacy waiver for individuals with significant privacy interests. and the information would be published annually in spreadsheet format. This would be massively useful for everyone from tenants who want to know who their landlord is, to financial crimes investigators, land title agents who are required to report the beneficial ownership of parties to real estate transactions, and who are currently, without that information, tasked with being sort of private investigators. Those who investigate financial crimes, such as the Attorney General's office or district attorneys, and many others. Then part 3, which will also be a standalone bill, will be, it will allow Department of State and Department of Taxation and Finance to verify beneficial ownership information with one another in order to identify fraud, which is another crucial piece of this legislation. Currently, the grantors or grantees of real estate transactions for residences with 1 to 4 residential units who are LLCs, have to disclose their members and managers to Department of Taxation and Finance. Part 3 would just change that to all beneficial owners of LLCs and all real estate transactions involving LLCs. So Department of Taxation and Finance would be able to check who the beneficial owners of LLCs are, especially those involved in real estate transactions with Department of State, in order to see if people are sort of fudging their disclosure forms. This would also provide sanctions for non-compliance, which is another crucial piece of the bill. And I've already talked a lot, so let's go to our speakers, unless the senator or the assembly member would like to talk.
Hi, John, I'm here now. Just wanted to let you know.
Hi, would you like to say a few words?
Sure. So thank you everyone for coming to this legislative briefing. This is a very exciting bill for me because not only is it related to international crimes and drug trafficking and all sorts of other very high profile problems, we're really motivated to write this bill from something that's very common in my district, which is landlords using LLCs and then not following through with their obligations for providing safe and affordable housing to their tenants. So we actually, we went out and we asked our constituents how many of them had LLCs as landlords and what was their experience with that. And we got quite a few submissions, but I'd like to read to you an email from one tenant in my district. Hi, Emily. Our building is a 36-unit rent stabilized building that was bought 6 months ago by an anonymous LLC that used a name different from the one that we pay our rent to. We have never been late on rent, but when we attempt to contact our landlord, there is no number and no contact information. We have a super, but they also won't give us the number. It's maddening to not be able to discuss the lease or any other issues about repairs with anyone. It feels like the repair request site is talking into the void. We have had a broken front door for 60 days and 311 was called 40 times. I have a 2-year-old son and our front door was broken for 60 days where I could have had anyone come into the building. I have neighbors who have withheld rent for 4 months and have still never heard from anyone. We don't know what to do, but we have organized into about 12 people who are really upset. This is the affordable housing that we need to stay in South Williamsburg. I'm a public school teacher and I can't afford higher rent. So as you can see, this is a very, very disruptive problem for average citizens in their going about of daily life. And LLCs are so commonplace that I was part of a protest probably back in 2017 that took place in front of a mailboxes, et cetera, in my district, because we absolutely had no information about who was the landlord of this building. And there's actually been sociological surveys done of people who own LLCs and who are doing business through them. And they found that when LLCs own housing, they tend to be much more hands-off and allow things to become degraded and broken and feel a real vanishing of a sense of responsibility. And this is actually documented as a pattern of people who have LLCs. So we felt it was very important to bring this into legislation to make sure that people who need to get in contact with someone who owns an LLC actually can find that information. So I'm very excited that we have so many transparency experts here, and also people who are interacting with LLCs on a daily basis and could use help. So thank you for coming, and I'm really interested in hearing the conversation with the advocates and the experts.
Thank you, Assembly Member. So we're going to jump into
Hi,
the
it's
list
Senator
of
Hoylman here.
speakers. Oh, hey, Senator.
Yeah, just wanted to say hello and thank my partner, Assembly Member Gallagher, and all of you for this very interesting presentation. I think it's eye-opening to a lot of our colleagues. I hope it is. I think we both hope it is. We hear about LLCs a lot at every level. Of course, as the Assembly Member mentioned, it's very granular. It's at the local level, but of course now it's an international issue as well. My refrain has been, since I first introduced an earlier version of this bill close to 8 years ago, my refrain has been, you're required to provide more information to get a New York City Public Library card than you are to open an LLC. And that's basically the truth. And we have to fix that for many of the reasons that we're discussing today. And I just want to thank you for your partnership and for sharing this very important information. I think we have a real chance to move this legislation. Of course, the session is quickly fading in terms of legislative days, but I'm hopeful that we can get it on the calendar and get it to the floor for a vote in the Senate.
Thank you so much, Senator. So we have a list of speakers I'm very excited about, and I think going first will be the Executive Director of Transparency International.
Thank you, and thanks for those hosting this briefing and for inviting me to participate. Very excited to be here. My name is Gary Calman, and I direct Transparency International US. Transparency International is it's actually the largest global coalition dedicated to fighting corruption. Here in the US, our office works specifically on a variety of corruption areas, but mostly right now focusing on the role of illicit finance and what the US needs to do to protect its financial system. So I am here to offer support to the bill, the LLC Transparency Act, and applaud the sponsors for this important piece of legislation. My colleagues who will follow me will talk more about, I think, how corporate transparency proposals work and some of the standards to increase effectiveness and tools that New York may want to look at to make sure that their law is effective as possible. But what I want to do is offer some background on the reform. When I talk about corporate transparency and we talk about beneficial ownership data, people often think of it as a technical or bureaucratic policy reform. In fact, let me say that corporate transparency is a foundational law enforcement tool, and it's key to the accountability for a litany of financial crimes. And I want to run through, folks mentioned some problems in the real estate sector and renters, critical problem, and I think some others will also touch on that. But let me start by saying that the premise of this bill is fairly simple. It's easy, and it should be easy, to establish a company in the United States. And most companies, when they register, they list on their forms who their owner is. Most people don't try and hide it. There's 30 million companies in America. I think about 70% are sole proprietorships or very small companies. And there's no confusion who owns them. No one's confused about who owns the corner pizza shop or the neighborhood bodega. And so this is not actually a burden on the vast majority of legitimate small businesses. However, when bad actors start to exploit our system, they don't list themselves as actors. And there's no state, including New York, that currently requires information on the true natural person who owns and controls the company. And many don't even identify anyone as an owner or a contact on the form. So why is this a problem? And let me offer some examples, beginning with, and it was mentioned, touched upon, the current list, the current search for oligarch money, the assets of Russian oligarchs. An anonymous company was established in Delaware, secretly owned by Oleg Deripaska, one of Vladimir Putin's closest allies. He was listed as an owner of multiple properties throughout the United States, including a $14 million townhouse in New York City. Anonymous companies involved in sanctions evasion in New York is actually not new. At one point, Iran, through its state-run bank, invested through an anonymous New York company in a building on Fifth Avenue in New York City. They had profited from their investment at the same time the US had sanctioned the regime. Imagine just for a minute what it means about our laws, that the safest place on the planet for Iran to evade our sanctions is by buying property in New York and putting their money in the United States. That alone should be raise concerns for us in terms of our national security. But there's many other actors, and I want to run through a few of them so people understand the extent to which anonymous companies play a role in illicit activity and dangerous and harmful activity in our communities. There's a report by a group called the Fair Share Education Fund called Anonymity Overdose, where researchers connected the use of anonymous companies to launder money from opioid trafficking. The Los Zetas cartel laundered millions of dollars through a company that they purchased, which was horse racing. And they actually not only were able to launder the money, but the racehorses they bought were successful. They were very good racehorses, apparently, and they made millions of dollars. So not only are we helping drug cartels bring drugs into the system, into our country, laundering their money, but they're actually able to profit off our financial system because of the anonymity they receive. And the anti-human trafficking organization Polaris reviewed the corporate registration records for 6,000 illicit massage businesses in the US and found that in only 28% of the cases had an actual person been listed on the forms. Law enforcement could go in and arrest the trafficked women, but they couldn't actually get to the people who were behind the trafficking operation. And the trafficking operation would shut down in one building, move across the street, and open up and continue to traffic women in horrible situations. A report by Global Witness, another organization called Hidden Menace, in which investigators found numerous instances of anonymous companies used by US adversaries to undermine our national security. In one fairly chilling case, they found out that the Department of Defense had contracted with a US-based company to provide services to troops in Afghanistan. It turns out that that company was secretly owned by individuals with direct ties to the Taliban. We were literally providing funds to the people that were shooting at our troops. So why is all this happening? There was a study out of the University of Texas, Austin, and some other researchers that found, after sending out thousands of emails to hundreds of countries using a certain metrics, that the US is in fact the easiest place in the world to open up an anonymous company. One response from a corporate formation agent in Florida, just to give you an idea how brazen this is, wrote back to them because these emails were clearly, suspicious transactions that they were asking. And one corporate formation agent wrote back saying, hey, this is clearly dirty money, could even be terror financing. I won't touch it for less than $5,000 a month. Now, what's scary about that example is not that there's bad people in the world. We all know that. What's scary about that example is, had he not actually put the first part of that and just said my fee is $5,000 a month, he would have done nothing wrong by opening up the company and opening up our financial system to the dirty money that was clearly going to be laundered. So let me end my comments here with two last sort of thoughts, and then I'll turn it over to my colleagues. One is that you will hear, despite all the need for reform, that there are some opposition, and some of you may have already started receiving opposition about burdens on business and concerns. And as I started my comments to say, it should be easy to open up a company in the United States. We want to be a business-friendly country. However, that doesn't mean that they deserve anonymity and secrecy that could undermine our communities. And so we actually talked to, when trying to pass the federal law in this area, we went out and spoke to a number of small business associations, and they did a series of surveys and polling to ask small business owners what they thought. And in one survey, actually, there was 3 different surveys, and the results were consistent across all 3 surveys. I'm just going to give you the examples of one. The survey was done by Small Business Majority, in which 84% of small businesses surveyed said that shell companies stealing contracts is a problem. 58% said it was a serious problem. 74% said that transparency legislation would protect them against fraud and losing out contracts. And quote, one person said, "I'm tired of losing contracts to con artists." So we actually think that this, for the real business, small business owners in America who are already listing themselves on the form, this is not going to create any undue burden. In fact, we do have real data and evidence from our allies overseas. When the United Kingdom instituted a beneficial ownership directory, they did a follow-up study on small businesses to find out how much the annual cost for small businesses, those they defined as less than 50 employees, were paying to upkeep and maintain their registration. What came back was an average of £2 a year, or which translates to about $2.70 per year. So this is not a burden and is actually welcomed by the small business community. With that, let me close out by saying that this is a foundational reform, as I said at the top. Think about it like this. It's not the only thing we need to do, but it is, of course, and it is critical that we do it. And the reason is, think about building a house. If you build a house with just a foundation, you can't live in it. We understand that. But if you build a house without a foundation, that house is going to fall apart. Beneficial ownership legislation for law enforcement is the foundation of the house. And so we applaud the sponsors and hope that the New York legislature will pass this swiftly. Thank you.
Thank you so much, Gary. So speaking next will be representatives from the FACT Coalition.
Great, thank you so much, Jonathan and Gary as well, and both Assemblymember Gallagher and Senator Wellman for having us. Good morning, and thank you for having me. My name is Ryan Garul, and I am here as the Policy Director of the Financial Accountability and Corporate Transparency, or FACT Coalition, a broad, nonpartisan alliance of members dedicated to standing up structural reforms that address vulnerabilities in the U.S. financial system that facilitate money laundering, sanctions evasion, corruption, tax dodging, and illicit financial flows. We are here today in support of the efforts that New York is taking to address financial secrecy in its financial, business, and real estate markets. With A9415, also known as S8439 or the LLC Transparency Act, New York can establish itself as a leader in reversing the United States position as one of the most secretive financial jurisdictions in the world. This undesirable status erodes the tax base of the US and our allies, undermines our national security and financial markets, and weakens democracy here and abroad. The financial secrecy offered by the US and our allies have also previously enriched and empowered potentially adversarial regimes, including those of Russian President Putin, giving his inner circle a backdoor to evade the bite of earlier sanctions and emboldening their corrupt and criminal behavior. What New York does to advance financial transparency matters. New York's economy represents more than 8% of the US economy and would comprise the 11th largest economy in the world on its own. New York has also in recent years taken notice of the ways that competition for financial secrecy among US states has often been targeted at eroding New York's straight treasury coffers, undermining public services provided in the Empire State. The LLC Transparency Act would leverage and in many ways improve upon reforms occurring at the federal level to require disclosure of beneficial owners of limited liability companies formed, operating, or transacting in New York. We urge the committee to consider advancing this important legislation today. My testimony will briefly cover first, the need for timely implementation of key beneficial ownership transparency reforms in the US to give everybody some background about what's happening at the federal level. Second, how the LLC Transparency Act would better protect New York markets as well as US markets more generally. And third, next steps New York might consider taking in buttressing our open democratic markets through transparency. Offering both financial security and secrecy, the United States has become a prime destination for the criminal and corrupt looking to launder their ill-gotten gains. According to the Tax Justice Network, the United States is the second most secretive jurisdiction in the world. As a result, untold wealth pours into US financial markets and real estate, whether that be in small towns in the Hudson Valley or towering Manhattan apartments. And as made clear by the Senator, Assemblywoman, and Gary at Transparency International, anonymous US shell companies have played a key role in perpetuating harms that undermine US national security, destabilize the US economy, and threaten global democracy. The FAT Coalition helped lead the way on passing the 2021 Corporate Transparency Act with support of law enforcement, national security experts, financial institutions, anti-human trafficking organizations, large and small business associations, and faith groups, as well as our coalition members like Transparency International. The CTA will once again once implemented, effectively ban the use of the most anonymous shell entities in the United States by requiring certain US entities to name their true beneficial owner to a secure federal directory housed at the Financial Crimes Enforcement Network, or FinCEN. Certain exemptions in the law should be closely watched by FinCEN for ongoing money laundering risks. The resulting directory will not be made available to the public, but will be accessible by state and local law enforcement officials pursuant to the statute. FinCEN is currently in the process of drafting key rulemakings to implement the act. The FAT Coalition has urged FinCEN to provide uncomplicated, complete access to the central directory for authorized state and local law enforcement officials. But separately, FinCEN has also solicited input on bringing greater transparency to the US real estate markets, advancing beyond the information gathering focused and temporary geographic targeting orders, or GTOs, that have been in place since 2016 in cities like Manhattan. Such measures would bring transparency to the enormous US real estate market, a market that should have been subject to full anti-money laundering and countering the financing of terrorism rules since Congress required as much in 2001. As it drafts the new rule, FinCEN should reform and expand its real estate framework by, among other changes, pursuing a permanent and nationwide reporting regime that would require real estate professionals to identify the individuals behind their entity clients. Reporting requirements should also apply to both commercial and residential real estate transactions without monetary thresholds and apply to both buyers and sellers of real estate property. But whether and to what extent state authorities like those in New York will have access to information reported under any final real estate reporting rules remains to be seen. New York has a key opportunity to take the lead among the states in the fight against global corruption here. We believe state level efforts like the LLC Transparency Act are a critical component of shoring up the financial safeguards at the federal level and preventing the abuse of the US financial system. The LLC Transparency Act would require domestic and foreign LLCs to disclose their beneficial owners in connection with formation or registering to transact business upon changes of beneficial ownership and in connection with certain tax filings. The bill would also set up a database to allow the public to understand the true natural owner behind currently anonymous LLCs. This transparency measure would give both law enforcement and the public a clearer view of the often complex structures behind LLCs, including those serving as landlords in the state. Such a step would ensure that New York does not remain a place for kleptocrats to stash their wealth and will protect the New York real estate markets and tenants. The LLC Transparency Act does more than just replicate the elements of the Corporate Transparency Act or the federal reform that Gary had mentioned. As of now, the CTA directory will not be available to the public, and certain exemptions and other limitations in the CTA may continue to provide opacity in areas where New York needs greater transparency. As FinCEN continues to draft the final regulatory language for the CTA, the LLC Transparency Act provides a better tailored solution for New York than the CTA standing alone. Maximizing the tools available to New York law enforcement, government officials, and others, and facilitating interagency cooperation within New York State to protect public safety and prevent the abuse of New York's financial systems and real estate markets for property owners and tenants. A public database, if and when passed, also increases the ability to verify the accuracy of information delivered to this database, as well as other government agencies on a continual basis. More accurate information is critically important, not just for administrative purposes, but for local businesses and tenants in lowering their own transaction costs and engaging with commercial suppliers, landlords, and others, as well as in seeking contracts. The LLC Transparency Act is an important step forward for New York. Building on this initiative, New York should continue to monitor the successes and potential unintended consequences associated with the LLC Transparency Act, and the bill provides the framework for doing so. The LLC Transparency Act focuses on LLCs as an important starting point for bringing transparency to New York markets. In other international jurisdictions, bringing transparency to a more limited number of legal entities has often encouraged formation and investment via legal entities not included in similar regimes. The bill requires reports regarding compliance with the LLC Transparency Act and review of whether other available legal entities or arrangements garner increased investments, meriting extension of the regime to additional otherwise anonymous vehicles. FAC would encourage New York to give serious consideration to applying similar transparency reforms to all legal entities, arrangements, or associations organized, operating, or transacting in New York or pursuant to New York law. Doing so would continue to leverage federal reforms under the CTA, minimizing compliance costs for all New York businesses, while also bolstering the CTA and New York's transparency efforts with respect to identified risky vehicles and arrangements that can currently invest in New York with anonymity, such as common law trusts. The LLC Transparency Act creates a solution that works for New York, leveraging federal reforms to minimize compliance costs while simultaneously increasing transparency and decreasing transaction costs for New York small businesses and renters. These reforms also set an important precedent for other state governments, solidifying New York's position as a leader in transparent, well-functioning markets. Tackling the challenge of kleptocracy and corruption requires a whole of government approach that goes beyond the federal government. Now is the time for Albany to lead the way by taking up the LLC Transparency Act and demonstrating how other state governments can do their part to keep illegal wealth out of US real estate markets and financial markets. Thanks again for having the FAC Coalition. We look forward to any conversation or questions.
Thank you so much, Ryan. So next we have the group Open Ownership, who have a few slides presented. Andrew, if you could pull those up. Also, we're running a bit behind schedule, and so I want to make sure we can get through all of the speakers if it's possible to speed things along. Please do. If it's not, don't worry about it. We might have to go over time a little bit. Hopefully everyone can stay. Thank you so much.
I'll try to keep it short. Thank you, John. John referenced this a couple of times, but I'm Tim and I work for Open Ownership. And if you go to the next slide, I'll say just a few words about us. So Open Ownership is a nonprofit that provides assistance to governments to help with the legal, policy, and technical aspects of generating high quality data on the individuals that ultimately own and control companies. High quality data means that it complies to international standards and meets the needs of data users, whether those users are within government, civil society, or the private sector. So since 2017, we have supported almost 40 countries to advance the implementation of beneficial ownership transparency reforms, including at the US federal level through our partnership with the FACT Coalition with Ryan and Gary, and we've supported the creation of over 50 new beneficial ownership registers. So one of our key work streams is producing evidence-based guidance and resources to help policymakers and legislators implement effective reforms. And to do so, we look at emerging good practice globally, and we collect the evidence of implementation and the impact from the work we do with governments. So the bill we're discussing today builds on some of these resources. And our final work stream is supporting people and organizations to use beneficial ownership data. And to do so, we've developed the world's leading data standard for beneficial ownership information and the world's first transnational public beneficial ownership register. Next slide, please. So a lot of this has been covered by John and also the Assembly member, but why beneficial ownership transparency? So the concept of beneficial ownership has been around for longer, but it's only since around 2015 that jurisdictions are centrally collecting and at times publishing this information. And often this is for a limited number of policy aims, often for complying with international anti-money laundering standards. However, as we see, it's a nascent policy area. New uses are still emerging and being identified constantly. So, firstly, as has been discussed, it can help businesses understand who they are dealing with and help them assess risk effectively. So this helps level the playing field for due diligence and helps foster a transparent business culture, which can attract investment. Obviously, this requires the information to be available to businesses as well. It supports effective government by supporting effective taxation, helping fight tax evasion. It allows governments and citizens to know who is behind companies and benefiting from public contracts, which can help foster accountability and trust. This became particularly apparent during the unprecedented government spending during the COVID-19 pandemic and all the stories of fraud and corruption sort of starting to emerge now. Thirdly, it helps tackle illicit activities by making it harder for criminals to move and hide the proceeds of crime by aiding criminal investigations and helping track and recover stolen assets. This also covers being able to enforce sanctions, which has already been covered. If you do not know who's behind a company and a company can own assets, you cannot enforce sanctions. And it seems that some of the New York State policy aims fit broadly within the effective government category, although if implemented and legislated for well, the scope of what you can do with the data increases. Next slide, please. So what is implementing well? What does that mean? So this is our understanding of emerging good practice coming together in what we call the principles for effective disclosure. This focuses on the technical characteristics of disclosure regimes to generate actionable and usable data across the widest range of policy applications. So broadly, this relates to the disclosure and collection of data. So today's act, how is beneficial ownership defined in law? The access to the data, which will be in part 2 of the bill. So whether it's made public or not, who has access under what conditions, what information is made public, and the last is data quality, which will be covered in part in the third part of the bill. So for instance, making data public makes the data available to additional user groups such as civil society and the private sector. This may be essential if the policy aim you're trying to pursue is accountability and oversight, or as I mentioned, it can allow small and medium-sized business owners to use the data for their own risk management. As mentioned, the compliance for them is probably the cheapest, and the benefit, the gains are probably the largest because sort of the third-party due diligence services available are very expensive and usually only available to larger companies. Another example, if the information is collected and published as structured and machine-readable data, you're able to join data sets from different jurisdictions and visualize transnational corporate structures like the ones that John showed in his introduction, or connected to other data sets such as lobby registers if you want to know what individuals are behind companies for political donations, such things. So open ownership found that the proposed bill includes some aspects of the best practice that we have identified, for example, in defining beneficial ownership. Although, yeah, as already discussed, the jury is still out on other aspects of how this will be implemented in New York State. For example, whether data will be made public, and if so, in what format and under what conditions this will be accessible. Next slide, please. So this bill comes during a time of substantial global momentum towards beneficial ownership transparency. The map shows national commitments. As you can see, there are more than 115 countries that are committed to collecting this information essentially, and over 100 of these have committed to publishing this information. This supports our view that the added value of publishing data is broadly acknowledged, including by all EU countries and the UK. Yeah, as mentioned, the UK has also made a federal commitment in late 2020, and FinCEN is currently working on its implementation, although unfortunately this is not set to be a public register under current plans. Next slide, please. However, so as we can see from this map, there's still a significant implementation gap. And what we're witnessing in our work is quite a bit of divergence in the quality of legislation and implementation. So as mentioned already, the implementation will largely dictate what you are able to do with the data and what policy aims you can achieve. And we've worked with a number of countries who suddenly realized further down the line that a decision they have made in the legal or system design ends up limiting what they're able to achieve further down the line. So hopefully some of the public resources that we put out there and this very brief presentation today can make sure that New York State can avoid some of these same pitfalls at this quite critical stage of legislation. Thank you very much. There's one more slide with contact details.
Thank you so much, Timon. So next we have the Community Service Society, followed by some members of the University of Buffalo Law Civil Rights and Transparency Clinic. At that point, we might hit 11 o'clock. If you have questions now, feel free to put them in the chat and hopefully we can answer them before the briefing ends or before some people have to leave at 11 for any other meetings.
Thanks a lot, John. Thanks to you all for organizing this, and thanks to Assemblymember Gallagher and Senator Hoylman for sponsoring the legislation. As John said, my name is Samuel Stein. I'm a housing policy analyst at the Community Service Society. I'm also a writer who writes about New York real estate and a former labor researcher, and all three of those identities would benefit from the passage of this law. So the work that we do at the Community Service Society is to survey low-income New Yorkers to understand their hardships and needs and wants, to study the effectiveness or ineffectiveness of current policy, and to advocate for alternatives. And I work in the part of the organization that's focused on housing. And we strongly support this bill, which would greatly reduce the amount of unnecessary secrecy that clouds the answer to the simple question, who owns property in New York, and especially for my uses, who owns rental housing in New York. Limited liability companies make it quite difficult and sometimes impossible to determine the answer to that question right now. And that frustrates tenants who are searching for their true landlord, as the Assembly member discussed earlier, investigative journalists seeking to uncover the owners behind problem buildings, and also building service workers looking to identify usually their contractor's employer, so their employer's employer. They're all frustrated by the same opaque ownership structures. And to give personal examples of those three identities, which I've shared at various times, right now I'm doing work on 421A, which is a gigantic tax break for developers in New York City. And I've been asked many times, which developers are benefiting the most from this tax break? And the answer is we don't know. We know buildings that are getting it. We know which LLCs own them. We do not know collectively which developers are behind all of those LLCs. So that's an example from my current work. As a journalist, I've been involved in projects that have been similarly frustrated. This example is actually from my wife. She was working on a film about subprime mortgage lending and uncovered a ring of deed thefters, criminals, who were opening up different businesses after they got shut down in county after county, and eventually got to Brooklyn and opened something called HPD LLC, which was a limited liability corporation intended to look as if it was a government agency that was in fact giving out fraudulent deeds, fraudulent mortgages. And then finally, I used to work as a researcher for SEIU 32 Beija, which is the large union representing building service workers. And we would try to get contracts that cover the entire portfolio of a given owner when we were organizing. It was, however, extremely difficult to track down the entire portfolio. And we knew that landlords who had a contract with us had buildings that they owned that were paying workers significantly less. And they were hiding behind the fact of LLC ownership. So as a housing activist and researcher, as an investigative journalist, and as a labor researcher, I've been frustrated again and again and again by this LLC loophole. And I'm really excited that this bill is moving forward. And I know there's more work to be done to make sure the entire bill gets passed. But I think representatives from each of those three groups, the tenant groups, the journalists, and the labor group should all be uniting together to push for that. Thanks again for inviting me today.
Thank you so much, Sam. And actually, I think we'll have Rebecca Lee from the group Open Corporates go next, followed by some members of the University of Buffalo Law Civil Rights and Transparency Clinic.
Thank you, John. My name is Rebecca Lee, and I'm the Chief Impact Officer at Open Corporates, which is the largest open database of companies in the world. Our mission is to deliver genuine corporate transparency, collecting and making public data on the existence, ownership, and activities of companies and the people connected with them for the benefit of business and society. We've pioneered the campaign for open company data, advising governments and company registers, and we would urge for this legislation not just to be passed, but to be built on to provide the register to be public. If you remember anything from my presentation today, it should be that a beneficial ownership register has a legitimate public interest purpose, and publishing it as open data maximizes its impact and the ability to combat crime. As you've heard extensively today, companies are the conduit for undertaking, concealing illicit activity, laundering money and spending funds. Owners of companies get the benefits, the influence, the profits, and control over other companies to do so, yet enjoy that limited liability and can remain anonymous. So understanding who controls and benefits from those companies is critical to ensuring a fair and transparent society, which is why 90% of the countries committed to beneficial ownership transparency have committed to a public register. It is far more risky to lie in public, where the many eyes effect from a multitude of stakeholders brings a far higher level of challenge and accountability. And those with a legitimate interest in knowing the ownership of company is really wide-ranging. Of course, it's law and tax enforcement and journalists, but it's every single business that needs to undertake due diligence on clients, their supply chain, their third parties, and also need to provide that information to do so, as it's been provided in one place already. It's key to understanding government procurement, political financing, land, real estate, and other assets ownership, such as yachts and real estate. And it's been used to combat human trafficking and modern slavery, even who's sponsoring deforestation. But really, it's every member of the public thinking about renting, buying from, or otherwise interacting with the hundreds, sometimes even thousands of companies we do a day. Not just providing our money, but also our data about ourselves as an individual. And we should know who is benefiting from that money and that information. The gold standard of registers is that they are open data, and the only way to ensure the register really achieves its intended objectives. And what I mean by that is that open data is free, it's machine readable, it's up to date, with an open license that doesn't restrict its usage. Experience already shows us that open data registers means that there's easy and efficient access for everybody. It increases the ability and reduces the costs to fulfill due diligence, risk management requirements, and conduct investigations. And crucially, it gives the ability to gain insight by combining ownership data with other data sets, whether that's sanctions, PEPs, procurement, other company registers, and asset registers. And being able to look at all of this data at once allows for the identification of suspicious patterns of owners, and where relationships exist across layers of multiple companies, across individuals, across addresses, which enables research and investigations, both by law enforcement and civil society, that just would not be possible by manually searching every single record. And allowing for that wider, more in-depth analysis increases the feedback, it increases the challenges, and overall the data quality. New York has already seen the importance and demonstrated its commitment to open data. So the open data portal includes downloads of active companies on the corporate register from the Division of Corporations. And there are already safeguards and mechanisms in place to manage privacy issues for those who should be protected, such as by the Address Confidentiality Programme. So in summary, a beneficial ownership register has a legitimate public interest purpose, and publishing it as open data really does expand its utility, significantly improves the data quality, and maximizes the benefits to the economy. Thank you.
Thank you so much, Rebecca. So if they are still on, I'm hoping that some of the folks from University of Buffalo can go next. I also want to briefly mention that the United Kingdom has had a publicly searchable register of all corporate beneficial owners online for several years now, as have a few other nations. But I think this has provided very much an excellent proof of concept and evidence that these sorts of things basically only have positive outcomes or positive effects for all members of society, whether small business groups, as Gary Calman said, but also civil society, journalists, law enforcement, and government auditors when they're, for example, looking into contracts. And so I encourage people to check out that register if they have the time. So without further ado, are any of the folks from University of Buffalo on?
Yes, we are here. Thank you. Good morning, everyone. My name is Heather Beija, and my partner on this matter is Petra Holness, and we are both student attorneys at the University of Buffalo School of Law's Civil Right and Transparency Clinic. Thank you for having us here today. I'm going to do a brief introduction and then share my time with Petra to talk about a little bit of what we've been doing. So we actually have been working on behalf of Partnership for Public Good, which also goes by PPG, which is a community organization that advocates for various policy initiatives in Western New York. Our role has been to research and find potential solutions to ameliorate LLC transparency in Buffalo. PPG is also partnered with People United for Sustainable Housing, known as PUSH, and together they are currently promoting a tenant bill of rights. And number 4 on that bill of rights is the right to know who owns the building. Currently, its efforts are really a focus on amending laws in Buffalo and gaining support for the tenant bill of rights. So why is LLC transparency important? Well, we've all said it, but from our view, LLC transparency has been a really important topic for us because bad landlords have been permitted to hide behind the LLC entity in order to evade accountability for housing violations and housing discrimination. Not only is this a problem for tenants, but it's also affected the city of Buffalo's ability to enforce housing codes and execute housing violations on LLC landlords that fail to meet the required housing standards. And Petra's going to talk a little bit about what we've been doing.
Yes, so like Heather said, most of our research that we've been conducting and some of the solutions that we've been trying to find are focused in the city of Buffalo, and we're trying to figure out, what the city would allow for more transparency in housing. So first, we started off by looking at the 2019 LLC disclosure law. It was introduced by Senator Skoufis. And that law on its surface, it required LLC owners to list their ownership on the required tax forms, but in practice, it doesn't actually compel agencies, such as like the Department of Taxation and Finance, to actually disclose that beneficial ownership. And then we looked at our city code to see how on a local level, the city could use the authority that they had to compel housing LLC owners to disclose their membership. And we found that the city could possibly amend their city codes requesting this information from LLCs. And one of the prongs, like Heather mentioned on the tenant bill of rights, is the right to know your landlord. And legislators here in Buffalo, they acknowledge that this is the issue, and they've been considering options to improve LLC transparency in Buffalo. But even with that, we still do see a grave need for state action because certain laws, they just don't go far enough to require disclosure from LLCs. So we need better document sharing between local state departments. We found that it was difficult to get information, even if it was foilable, because the different departments didn't seem to have a system to accurately share filing documents. Also, tenants, they really don't have the knowledge sometimes or the time to wait for FOIA requests. And if anybody is familiar with New York Freedom of Information law, it is not the most timely thing. And sometimes agencies aren't the most forthcoming. And we also found a great need for a user-friendly database, like everybody has been saying, to disclose membership, and one that is accessible to tenants and city officials so that they can easily access it. And actually enforce housing codes and housing violations. So, and there's a need for a broader reach of different kinds of housing. So we really appreciate the part of the bill that extends to all housing, not just like the limited 1 to 4 residential dwellings that was in the law before.
Just to conclude, the LLC Transparency Act would prevent bad landlords from taking advantage of tenants and usurping the city's and state's ability to enforce housing violations. We do hope that the public registry component as a companion to the LLC Transparency Act will be adopted, as that would be a huge benefit to tenants. And on behalf of our client, we appreciate the efforts put forth by Assemblymember Gallagher and Senator Holman's office in creating this legislation and advocating for this important matter.
Thank you so much, Petra and Heather. So our last speaker will be Michael Kink from Strong Economy for All, and then we can take questions if there are any remaining.
Yeah, thanks, John. And I'll go quick. You know, you've heard that it's an international criminal problem. You've heard that it's a huge tenant problem. I'll co-sign with Sam Stein that it's a labor law and worker protection problem. It's also a tax problem, both on corporate subsidies where corporations are scamming workers, violating environmental protection laws, and still drawing down corporate subsidies. So knowing the shell companies, knowing where they're hiding their money is important. Straight up tax fraud, hiding money, not paying taxes on it, a huge issue. It's also a campaign finance issue, right? A couple of years ago, we quote unquote closed the LLC loophole by subjecting LLCs to individual contribution limits rather than the massive unlimited corporate limits. But, you know, for anyone that's, you know, one of my personas has been a researcher on campaign finance laws. And when you see page after page after page after page of LLC contributions, you know, sometimes you know it was Leonard Litwin, but right now it's 100% secret. And so all of these things that you've heard folks talk about could be happening in the campaign finance realm as well. So the last point I'll raise, and why all your bosses should do this, and you should all get to with the speaker and the leader to push it now, is that it is a huge political issue. With the war, with the Russian oligarchs, the combination of the worst villains in New York, greedy landlords, tax frauds, campaign finance cheaters, plus Russian oligarchs, like now's the time to do it. So, you know, if you didn't hear what you needed to hear, please dig in with staff for Senator Hoylman and Ms. Gallagher. I think that this bill can and should pass before the end of session, and I hope that all of you will go and jump on the bill right now.
Thank you so much, Mike. Well, if there are any questions from anyone in the audience, feel free to raise your hand. Otherwise, everyone can hop off. I appreciate that everyone was able to stay on for a few more minutes to listen to our really incredible lineup of speakers.
I don't see any raised hands. I'll also mention that this entire event was recorded. I'm not sure whether we'll put it on YouTube perhaps or cut it down for various things, but I'm the Assembly Member's Chief of Staff. I'm putting my email in the chat. If this video recording will be useful to any of you in your advocacy efforts, if you want to review any of the materials, please feel free to email me and I'll make sure that you get the video, and you'll also see clips of it on the Assembly Members' social media. John's email address is in the chat as well. As John mentioned, we're hopeful that this will actually, as we speak, moving through the Corporations Committee of the Assembly and onto the floor. And we heard encouraging words from Senator Hoylman about its prospects in the Senate. So we are feeling optimistic, but everybody on this call who's in the capacity to do so, if you work outside the legislature, or frankly, if you work in the legislature, you know, please encourage members to co-sponsor this legislation, to champion it, to advocate to the legislative leaders to get this to the floor as soon as possible. Albany, for those who don't know, has a kind of truncated legislative calendar that ends for the year on June 2nd. And so the remaining legislative days are dwindling. We do have a real opportunity to do this year and do this right now, but it will take a collective push. So thank you.
Thank you, everyone. Have a good day.
I'll leave the Zoom up for a couple minutes if anybody needs to take the email.